Thanks to Indochino for keeping Legaleagle in the air and helping me look fly.
To this day, it's still hard to imagine what $2 billion actually looks like. But I think that jury wanted to send a message.
Hey Legal Eagles, welcome back to the channel, and we have a special guest with us here today. One of the greatest trial attorneys in America today and an old friend, Brent Wisner with the law firm Baum, Hedlund, who has, I think, received every accolade you can receive as a trial attorney these days. And I think most people recognize you as the attorney who won $2 billion from Monsanto just a few weeks ago. So Brent, welcome to the channel. It's great to have you here.
Thank you, Devin. It's good to be here. It's always good to see an old friend.
So I think what people would really like to hear is, what is it like to win $2 billion from Monsanto? It's
pretty unreal. I mean, I remember sitting in the courtroom when the jury was reading the verdict, and it was two different plaintiffs, right? Both Al and Alberta. And when Al's verdict came, he got $1 billion in punitive damages. And I realized, oh my God, they're going to give us two. And I remember I turned around, looked at my associate, Pedram, and I went, and it was pretty unreal. To this day, it's still hard to imagine what $2 billion actually looks like. But I think that jury wanted to send a message, and I gave them an opportunity to do that. It was pretty cool.
All right, so let's take a step back for a second. If people aren't familiar with the Monsanto litigation, the Piliad case is the third of three cases, and you've tried two of them. Let's start with the first one, where you only won $289 million. That was the Johnson case. Can you give us some background about what that case was about, what the basics of the case were, and what your theme going into that trial was?
Sure. So, I mean, these cases are about a chemical called glyphosate, which is an active ingredient found in the Roundup herbicide or pesticide. Just to give you a sense of how much has been sprayed in our society, the amount of glyphosate that's been sprayed in the United States by itself is more than every other pesticide ever combined. It is in everything we eat. It is everywhere we go. And Mr. Johnson and the Piliads, they sprayed Roundup for a considerable period of time. And after spraying it for a period of time, they got something called non-Hodgkin's lymphoma. Different severities of cancer, but it is a pretty severe cancer. And so we brought a lawsuit against Monsanto, one of the most hated organizations or companies in the world. And we sued them.
Allegedly.
Allegedly, yes. But I mean, it's really funny. I've gotten more free drinks at bars telling people that I sue Monsanto than anywhere else in my life. The first thing I say to somebody when I meet them, I'm a plaintiff's attorney and I sue Monsanto, and they go, let me buy you a drink. So anyway, we brought a lawsuit, and I think the theme, the main principle behind both cases, in fact, it was the first words out of my mouth in both opening statements, was that this is a case about choice. It's about the right of every single person in the courtroom to make a choice about what chemicals they expose themselves or their family to. And knowing whether or not it causes cancer is part of that choice. And that Monsanto has robbed that choice of every single person in this courtroom, the Piliads, Mr. Johnson, and in doing so, they caused cancer. They've actually taken lives. And so you have to do something to fix it. That was a big part of the case. That, and also trying to make the case seem like a truly historical moment. I mean, that's a really important way to frame a case, because if the juries don't want to be there, but if you give them the idea that they're making history, I mean, you can really take them as far as you need to go.
I mean, there's so much I want to talk about here.
Sure.
As an attorney myself and a trial lawyer, I mean, I'm chomping at the bit to talk about every single aspect of trial tactics here. Let me start with this. How did you decide on that particular theme? And is that a theme that carried through both through the Johnson litigation and through the Piliad litigation itself?
I spent a lot of time thinking about it, and I kept coming back to, what is the moment, right? What is the moment where the actual tort occurs, right? And it's not actually when you're spraying, because when you're spraying it, you've already made the decision to purchase the product. And I realized that all these cases come down to a moment when you're sitting there in a store, a Home Depot or whatever, and you're looking at this wall of Roundup and you're thinking, should I buy this stuff to get rid of the weeds in my house? That's that moment. And that moment's captured by a question of choice, right? And I feel like putting the jury and putting basically everyone in those shoes gets you to a place where they go, okay, I can see how this lack of disclosure of the cancer risk could actually cause a real problem. So that's how we got there. And I kept going different ways, different themes, and I kept coming back to that moment.
Yeah.
And that moment was about choice.
So to take one step back, I mean, this is history-making litigation.
Right.
And you have a long history of being a trial lawyer. But my understanding is that you did not start with this case as, well, at least the Johnson litigation. You were not originally the lead trial lawyer for that case.
Yeah.
How did that come to your desk, and how did you become the guy that was going to be the lead trial lawyer who was going to actually try the thing in front of a jury in San Francisco?
Well, I mean, Devin, you and I know that, you always want to be the lead trial lawyer. You always want to be in the thick of things. You always want to do the opening. You always want to do the closing, because that's what I live and breathe for. Back in college when we were doing this in our mock trial days at UCLA.
And we're definitely going to talk about that.
Okay, of course. I mean, you did teach me most of the things I know about being a trial lawyer.
Oh, stop. Flattery will get you everywhere.
But so 2 weeks before the Johnson trial, and I had been working on the Monsanto Roundup litigation sort of generally for about a year and a half. So I knew the science, I knew the experts, I knew how to prove the case, at least on paper. Mike Miller, who was the lead trial counsel, he's 7 years old, and he was out kite surfing on Virginia Beach.
Wow.
Power to the guy, 7 years old, and he's still kite surfing. I hope I am doing that when I'm 70. And his safety harness didn't work right, and he ultimately went 30 miles per hour into a pier. He was in a hospital. He almost died. It was pretty horrible. Well, number two at his firm, Tim Litzenberg, literally leaves the hospital and calls me and says, "Hey, Brent, we got this case going to trial in 2 weeks. Can you help out? Like, we can't do this by ourselves." And I said, "Absolutely, man. Whatever you need, I can do it." Well, the next Monday, he then had a grand mal seizure, and he was hospitalized for 7 days. And basically, I was the last man standing, which is one of the reasons why I, at 35 years old, was put in this really important position of trying a massive historical first case against Monsanto involving Roundup. Mike Miller calls me from his hospital bed and says, "Brent, go get him." And, I did. And ironically, in the last trial, in the Pilliod trial, in my rebuttal, after the closing, the last thing I said to the jury is I actually looked at them and I said, "Go get him." So kind of came full circle.
So we used to joke in college and in law school that the ideal job for a trial lawyer is not to have to work all the discovery and all the motions and the paperwork, but to just get called in at the last second and get to go to trial. Somehow you got to a position where you're living the dream. And I mean, that on the one hand sounds amazing. That's exactly what we always wanted to do. But getting a multi-million, potentially multi-billion-dollar case a week before trial, that also sounds like the most terrifying thing I've ever heard in my entire life. How in the world do you go about preparing for that kind of a trial when the whole world is going to be watching you?
There's a lot of hyperventilating. There's a lot of not showing how scared or nervous you are. But I also think part of being a trial lawyer is sort of relishing that pressure, relishing the anxiety of the moment. And I actually remember thinking, that morning, just before the opening statement, it was like, this is it. This is what I've been waiting for my whole life. This moment for this trial, to be brought in, complete underdog, taking on these massive corporate lawyers who are the most seasoned in the country, and taking them on and beating the crap out of them. And that's literally the dream. But, one of the things that people don't realize when it comes to trying a case, and obviously you know this, Devin, but, the trial is this small part of hundreds and sometimes thousands of hours of work that leads you to that moment, particularly in these complex mass tort cases. And so it's, you got to relish the moment when you're there.
Yeah, I mean, it's a curse and a blessing that if you are working on a case for sometimes years, the case like the back of your hand. It's your baby. You know it as well as your own physical child. And so when you get to trial, you don't have to work it up in the same way as if you were just coming in fresh, but without having that benefit of doing the discovery I mean, how long was the discovery, the part of the iceberg that we don't see, trial is the part that we do see. How long was that litigation going on before it even got to trial?
Well, to give you some context, this is a good way of thinking about it. So there was, I think, 36 depositions that had happened prior to trial.
That's a good number of depositions.
Each deposition is 7 hours long, minimum.
Mm-hmm.
And each of those depositions probably takes 100 to 200 hours of prep. So you start doing the numbers there, and it becomes sort of astronomical. In addition to that, there was over 10 million documents produced by Monsanto. We had scientists from around the world. We had a lot of third-party discovery against other scientists. I mean, it was a complicated case. And, one of the things that we did in this case, at least in the Johnson case, and we did in Pilliot as well, but in the first case, one of the things that I did that everyone thought I was crazy for was I wanted the smartest jury I could find. I wanted PhDs. I wanted lawyers. I wanted people who could understand complex scientific issues on my jury, because I knew that if they were just, lazy, not smart people or whatever, they wouldn't spend the time to understand the science, because when you look at the science, we win. But if you just believe the EPA or whatever, you lose. And so you need to have people who are willing to look at it truly in a new unit of time and give you an actual assessment. So that was pretty dangerous trial strategy, but it worked out.
Yeah, so on the channel we talk about the voir dire process, because that is actually one of the things that does show up in the movies and TV shows sometimes, is that you will see the dramatic selection of the jury. So let's dive into that.
Sure.
What is your philosophy when it comes to jury voir dire, which is the selection of the jury? It's the part that non-lawyers actually do have some familiarity with, because they get called for jury duty, and you might be impaneled on the jury, and you might have to get questioned by an attorney. But how do you go about doing that process? And obviously your philosophy with this particular case was get the smartest one that you could. What does that process look like from your perspective?
Well, it's an interesting process, because most people who are in that jury veneer, right, which is the group of people you're picking a jury from, most people don't want to be there. Right?
Yeah.
Most people want to avoid jury duty. And so the first sort of metric is you want to find the people who want to be there, right? Because people who want to be there will be more engaged, they'll be more interested. The people who don't want to be there will be half asleep most of the trial, right? The other thing that you want to do is you want to get them talking. Lawyers love to hear themselves speak. It is what we love to do.
Excuse me. Let me vehemently agree with your statement there. I'd like to continue to pontificate and agree with that statement about the vociferousness of attorneys.
I mean, the loquaciousness of lawyers is quite astounding, and how much we like to talk about things that we even agree on at times.
100% agree.
So one thing is to get them talking, right? Because you need a jury to talk. You need them to say things and speak their mind. But I think one of the other things is, this is a strategy that we use, particularly in San Francisco. I mean, you're in San Francisco. This is not a jury pool that likes Monsanto. This is not a jury pool that likes GMOs, right? These are people who eat organic and want to live a healthier lifestyle. So there's a natural dislike of Monsanto walking in. So one of the things that we did from the very beginning is to downplay our case. I mean, the first thing we say to the jury is, nothing can be proven, right? Cancer can't be proven. That's impossible. Who here agrees? Who here agrees? Because we want people to say, yeah, you can't prove cancer. We want them to sort of dislike the case, because when they actually get into the jury trial, we're going to win them. But we want to weed out the bad people. And so much of our job is finding the bad jurors and then, trying to get them to be willing to be on the jury, because it's so easy to get out of jury duty. You just say, oh yeah, I hate Monsanto, I can't be impartial, and then you're off. So you got to get those people to not say that, or say, oh, well, I don't like Monsanto, but I can put that aside and be impartial. And so that was the fight. I mean, when it comes to jury selection, that is the fight.
Yeah. So let's dig down into some of the minutia. When I was trying a case, I wanted to be as relatable as possible to the jury, and
Sure.
You're not allowed to talk to the jury outside of the selection process and the actual trial itself. But I remember I was walking through a metal detector, and I saw some of the members of the potential jury, and I made a big show of taking the metal pieces out of my pocket, like, oh gosh, I'm stuck here just like you are. Is there anything that you do to use every piece of the court process available to you so that you can ingratiate yourself with the jury and the judge and sometimes even the bailiff and people like that?
So, I mean, the first thing you do is you introduce everybody,
Mm-hmm.
right? Not just the lawyers, the paralegal, the person who's operating the tech. At my last trial, I actually introduced my parents who were in the gallery. I introduced, Bobby Kennedy, who had been a mentor of mine. It was like a name parade of all these people who are part of our team. It shows that you care about everybody on your team. I think people relate to that immediately. The other thing that you have to do is not be above anything, right? So many lawyers are like, well, I'm not going to move chairs, or I'm not going to deal with binders or whatever. I have people for that. I never let anybody do anything but me. I'm the one moving chairs. I'm the one handing the mic around, giving it to different jurors. They see that I'm a person who has no sense of pride or ego, that I'm just there to do my job. And I think that builds an incredible amount of credibility. And actually, at the Piliad case, it was so bad that during voir dire, there was a break. The judge actually goes, when the defense counsel goes, Judge, Mr. Wisner is being too helpful. He's handing around microphones and glad handing the jury. Can you tell him to stop doing that?
Oh my God.
It was actually quite funny.
Is there anything that you can do in the jury voir dire process to show that you are just one of everybody else, apart from, taking all the boxes and getting an objection, drawing an objection that you're being too helpful? That's a fantastic objection to get.
So I think it's really important to relate. I mean, first of all, put yourself in the shoes of these jurors, right? They don't want to be there. They want their jobs. They're worried how long the trial is going to be. They're worried about, oh my God, am I not going to get paid for 6 weeks? There's so many things that they're worried about. And so, one of the things is, everyone starts introducing themselves. Very beginning, hi, my name's blah, blah. Hey, my name's blah, blah. I always go up there and go, hey everyone. And I get them to say, hey back. And I go, I'm so sorry. I know none of you want to be here. Frankly, it sucks, but I'm going to do everything I can to get you out of here. But if I pick you, it's because I really like you. Sorry. And they all start laughing, and you immediately start creating a rapport with them in a sort of genuine way, right?
Yeah.
Not in like a false pretense way. So for example, the defense lawyer, he actually saw me doing that. He was like, oh, I got to do something charming too. He goes there and he goes, hey everyone, I'm from Nevada, Las Vegas, and but don't hold it against me that the Raiders left, right? And everyone was like, San
Francisco's not the right town to make that joke.
Exactly. He didn't understand where he was, right? And no one, that's assuming a lot of things, right? If he had made a Warriors reference, that would have been a really good thing to do. But he didn't get it, you know what I mean? And sort of relating to them in a real way. And I think a lack of sincerity is obvious. When someone's being untruthful, you know it. But when someone's being real, you immediately go, oh, this guy's a real person, I like him. And that's a really important part. You don't win the case by the jury liking you. The jury can hate you and you can still win or lose. But if they like you, it takes away a weapon of the defendant. Because when they attack you in closing argument, or they attack you in front of the jury gets defensive. They go, what are you doing? I like that guy. What are you doing? You can't attack him. And that actually has happened in all the trials. Monsanto always comes after me personally, and it always backfires every single time.
Yeah, that's so huge because a lot of lawyers, and I probably put myself in this camp, say that the trial itself is won and lost on credibility. You have one opportunity to put your case out there, and if the jury doesn't like you or the judge doesn't like you, it's going to be a huge uphill battle. And maybe credibility won't win the case for you, but if you lose your credibility, I think you're just done. It's there's no way to recover from that. Are there things that happened in the Johnson or Piliad case that you think bolstered your credibility and the credibility of your witnesses that helped build that in front of the judge or jury?
Yeah, I think there's a split within the trial lawyer community. There's the group that says never show weakness, always be right, always be the alpha dog in the courtroom. I don't agree with that at all. I think that's the terrible approach, particularly in a more dynamic and diverse environment like San Francisco. I think being real is way more important. And so, for example, in the Piliad case, during my opening statement, I actually said a fact that was wrong. I said that they'd sprayed over 1,500 gallons of Roundup. And it's actually, they had sprayed it for 1,500 days, but not 1,500 gallons. And I said that wrong, and I realized that I'd said that wrong. And so the first witness I had that had to deal with this issue, I go, hey, Dr. Sawyer, listen, during opening statement, I told this jury that they had sprayed 1,500 gallons. Is that true? No, it's not. What did I get wrong? Well, it's 1,500 days. Thank you, Dr. Sawyer. And I apologize, ladies and gentlemen. I shouldn't have done that. I just say it, I own it. And you do that, and it shows a level of a willingness to be wrong in front of the jury. I think it goes a long way because they know I'm not trying to fool them, that I care more about the truth than I do necessarily about, being right. And if you do that, then it leads them to the world of, okay, here's the evidence. I believe that evidence. Here's their evidence. I see that evidence. I'm going with the guy I believe.
Yeah.
And that's how you win.
God, I mean, that's such a great point because no case is ever going to be perfect. So you're going to have bad facts, or you're going to have bad law, and you're going to have to craft your case around those potential weaknesses. And I love that story because you're turning a weakness into a strength. You made a misstatement in your opening statement, and if it just stayed there, the other side is going to have the transcript. They're going to have the recordings. And at closing argument, they're going to bring that out and just say, you can't trust Mr. Wisner because he made this statement.
Exactly.
And instead, you use that as part of your case in chief. You come out, you acknowledge the mistake. And in the grand scheme of things, it doesn't matter. It's not like the jury is going to rely on this one fact forever. But now you have shown that you are a trustworthy person.
Exactly.
And even if it makes you look stupid in the short term that you did something wrong or you had a misstatement or you made a flub, the jury knowing that they can trust you is probably more important at the end of the day.
And where you see that the most is actually in direct examination, right? So direct examinations are a show, right? You have your witness, you know what they're going to say. You've practiced the questions, you know what their opinions are. There's no surprise here. But what I'll do is I'll actually ask some pretty harsh questions to my own witness. I'll go, hold on, doctor. Wait a second. Who are you to say the EPA is wrong? I mean, what gives you the right to say that this organization is wrong? Now, obviously, I've cleared this question with them beforehand. Right? I'm not just dropping this in their lap. But I play a sort of devil's advocate in my direct. And it creates so much credibility because there's somebody in that juror who had that exact question. Who was like, wait a second, who is this person, right?
Yeah.
And you always have a great answer. So for example, Dr. Portier, he was saying how the EPA didn't apply their own guidelines to glyphosate, and that's why that came to a different conclusion. And I'm like, well, hold on, Dr. Portier. Who are you? Who are you to tell this jury that they're not following the EPA guidelines?
This is your own witness.
This is my own witness. I'm like, come on, look at the jury, who's this guy think he is? And he goes, well, Mr. Wisner, I wrote the guidelines. Okay. And then I move on. But that's a more powerful way of getting to that question and answer than saying, so you wrote the guidelines. Does that mean that you can criticize? I mean, you know what I mean?
Right.
Being a sort of confrontational direct examiner can go a long way into sort of convincing the jury that you really do have the goods.
I think that's a great segue into some of the inaccuracies of what people see on TV and in movies. Obviously, nobody's going to want to watch a movie that deals with literally years of just reading documents and writing briefs. So it's no surprise that Hollywood will try and condense these things into a more palatable drama. Although you can come to Legaleagle to watch me talk about the accuracy or lack thereof in all of these TV shows and movies. But given that the trial itself can last days or weeks and sometimes months. For example, how long was Johnson? How long was Pilliod?
The Johnson case was 6 weeks and the Pilliod case was 9 weeks.
Okay, wow. I mean, imagine being on the jury for 9 weeks, having to be away from your family and your job. Obviously, a lot of it's just going to be shuffling papers, entering things into evidence. How do you keep the jury's attention and make sure that they pay attention and get the really important facts, even when you're dealing with sometimes really, really elaborate and obscure, scientific issues?
It's really interesting. I'd love to see how cases were tried before the film industry, because it's really a chicken and egg situation because everyone has seen so many movies where they've seen all this drama. They've seen Law and Order. I mean, that's actually why I became a lawyer. I like Law and Order. Like, that seemed like that would be fun. My job in many ways is to create sort of cinematic drama in the courtroom when it wouldn't naturally be there. And so there's different ways of doing that. I mean, I try, so when I'm cross-examining, I make it a point to storm around the courtroom, throw documents, slam them on the thing, point, cajole. And I do that not necessarily because it's more convincing, but because the jury goes from like, oh, ooh, what's going to happen next? You know what I mean? They get into, I'm watching a movie now. This is what I thought trials were about.
Right.
So it's funny. Hollywood has actually created an onus on us to make it Hollywood when it wouldn't naturally be that way. And it comes in different ways. And I think it comes in cross-examination because there's tension there.
Yeah.
It comes in openings. It comes in closings. There's a really powerful thing to do when you're on direct. And it's something that very few attorneys are willing to do. Again, it goes to credibility. But it's where I ask the witness a question, and the answer's bad for me. And I'll be like, so, sir, based on all this, it clearly causes cancer. And he's like, no, I wouldn't say that. And the jury looks at me like, oh my God, what just happened? Like, this is all gone sideways to him, and it makes it entertaining. So you have to create those dramas as much as you can. And I'll be honest, I did some of that in the Piliad case, I think, in a way that, probably angered the judge. Do you want to tell you an example?
Yeah, do tell. So you crossed a line and made too much drama.
I took it a little far. So we had, it's a Roundup case, right? So it's a pesticide, and we actually had a container of the Roundup that Mr. and Mrs. Piliad actually used on their properties. And we had cleaned it out. It was totally cleaned out. And I had an expert on there, and I picked it up, and he's like, you should be wearing gloves. And I'm like, oh, sure. Put on gloves, and I'm holding it. And that wasn't planned. That actually was a natural sort of thing that occurred. And as I'm kind of demonstrating how it gets used, and it shows you how it gets on your leg and all that stuff, I realized that there was a hydraulic pump on it. And I was like, oh, look at that. It's still working. And so I pulled the hydraulic pump, and I said, so you like this? And I go, and you spray it. And this mist came out. And it was right next to the jury.
Oh, no.
And two of the jurors were like, oh! One juror was like wiping his face, all freaked out. And I was like, oh, boy. And the judge was like, Mr. Wisner, why don't you put that away right now? I was like, yes, Judge, Your Honor. I put it away. And then one of the jurors wrote in a question, because they could write questions in California state court, and they said, what was in the container?
Oh, God.
And so we had this long debate with the counsel and the judge. And the judge ultimately gave a curative instruction, which is, disregard or whatever. And the original curative instruction that Monsanto wanted was to disregard everything I said about the bottle. I was like, well, Your Honor, that's not really fair. That there was a lot of relevant testimony. It should really just be about what was in the bottle. She's like, okay, fine. So the jury comes back in, and she goes, ladies and gentlemen, I just want you to know that there was only water in that bottle, so it's perfectly safe. I probably pushed that a little too far. When I have a juror who's worried about being, sprayed with chemicals, I probably have taken the drama too far, but they paid attention.
I mean, that's an advanced trial tactic. I love that sort of inside baseball that actual trial tactics have been changed because of the public perception. And again, as any good trial lawyer would do, you're turning a potential disadvantage that people are bored from watching a multi-day, multi-week trial, and you're turning that on its head by creating drama to punctuate the points that you're trying to make. In these particular cases, do you think that other attorneys are using the same opportunities that you are, or do you think that you're outside the norm in being able to create that drama and use that emotional punch when you need to?
I think that there's some plaintiffs lawyers, trial lawyers, who are doing this on a regular basis very effectively. In fact, I've learned a lot of my techniques, other than, of course, from you, from when we were in college and doing mock trial at UCLA. But, Mark Lanier, he's probably considered the most preeminent trial lawyer in the world, plaintiff side. And I've learned a lot of these techniques from them about how to create interest where other one's lacking. A really good example is depositions. So we take these 7-hour depositions.
Right.
You cannot play a 7-hour deposition to a jury. They will kill you. Okay. They are so boring, and there's so many legal technical questions that get asked.
The deposition being questions taken under oath outside of the trial itself. It's part of the discovery process where you're in a conference room, you're just asking questions, there's a stenographer writing down the answers, exactly. And sometimes things go wrong and you might have to call on the judge, but for the most part, the judge is not there. It's just you, the witness, and opposing counsel. Right. So, these now they're limited to 7 hours. Before you could go much longer. Yeah. The federal rules have allowed you to go longer now. These can be very, very boring things. Hey Legal Eagles, it's Devin from the future. I just wanted to pop in real quick and let you know that today's interview was brought to you by Indochino, my favorite suit maker. I'm wearing an Indochino suit right now. I was wearing an Indochino suit in the past when I was conducting this interview. It actually worked out really well. I brought a sport coat with me, and Brent happened to bring one too. We were like, why don't we have an interview with each other? You just won $2 billion against Monsanto. That'll be interesting. And yeah, I love my Indochino suits. And I actually asked Indochino specifically to give Legal Eagles the best possible deal, and they were happy to oblige. They gave Legal Eagles the exclusive ability to buy any premium suit for $359. That is the best deal you will find anywhere. All you have to do is enter the promo code LegalEagle at checkout. If you have any inclination to get a new suit, you owe it to yourself to try custom. That's the promo code LegalEagle at checkout to get any premium suit for $359 for a fully custom suit. And believe me, once you get a custom suit tailored for you, you will never ever go back. And I really appreciate you guys using the promo code or using the link in the description. It really helps out this channel. But enough of all of that, back to the interview with the guy that's gonna take down Monsanto.
And so, one of the things is, and obviously you want to play certain portions of it. So like in California, because of the subpoena limitation powers, I can't force a Monsanto witness in St. Louis to come testify at my trial. I can't. So I only can play videos from deposition. So one of the things that we do to make them more interesting is we use 3 cameras. We use one on the questioner, one on the witness. We have a camera on a document camera or a whiteboard. We even have a camera on like documents in another way. We can actually have 4 cameras. And what we do is we film all of them at the same time. And when we play them to the jury, it's like a television show. It goes to the question, it goes to the answer, it goes to the question, it goes to the answer, because they've done studies, right? People are used to watching clips for 12 seconds at a time.
Right,
A screen changes every 12 seconds. And if you don't have that, it gets boring and they fall asleep. And so we've had a lot of really, really, really good reactions to causing that back and forth in our depositions. And it kind of become like kind of more dramatic and they kind of more fun. And it goes to the document camera and it goes to the person. And, one of them I actually did where I was standing and the camera was following me as I was asking questions, like full on.
You were standing in a deposition?
Yeah. They were filming me as I walked around so it could look more authentic.
Yeah.
Become more interesting for the jury.
Yeah. Wow, 3 cameras. I mean, can you imagine someone being so vain as to use 3 cameras?
Shocking. Who would do that?
Yeah. But I've actually never heard of that. That's a great tactic to know that, some depositions are going to be important enough that you're going to show it to the jury in trial. So you use a multicam setup to be able to cut while they're saying the same thing. Mm-hmm. It's not breaking up the actual testimony, but you're using it to keep the attention of the jury. I mean, you're thinking so many steps ahead.
Yeah. I mean, whenever you're litigating, and obviously different lawyers have different approaches, but at least within my firm, and at least personally, everything is towards the trial.
Yeah.
Like every question I ask is, how is this going to be used at trial? Everything has to be. And if you do that, you do it right, well, then you get to go to trial and get $2 billion verdicts, right? I mean, that's how you do it. And, so many lawyers are so busy or so used to settling or so used to not actually being a trial lawyer. That's the big difference that you see today is the good trial lawyers have everything about trial and how we're going to present it. I mean, we do things, I'm pretty maniacal. For example, like my table, a counsel table in front of the jury is meticulously organized. I have everything in the same spot because studies have shown that if you look more organized, juries believe you more, right? Even you said nothing different except that you have an organized desk. That's it. And it's amazing how little things like that can really cue a jury in to being like, okay, this guy's for real. I trust him. Yeah. And it's hard because I'm so young, right? I don't have that much gray hair. I don't have the sort of seasoned old person thing. Right. So I got to show that I know everything. Everyone has to believe that lawyer knows more than everybody. And everyone believes that. And that's kind of my goal.
I mean, that's so funny because do you remember in mock trial when we had the idea that we would get rid of all the paperwork on the desk at all and only have this like tiny 8x5 little sheet to scribble notes on. And that would be the only thing we had at counsel table. I don't think that worked very well. You must have improved on that
we have some new systems, but I'll tell you one thing that we haven't changed is I don't use a script. Every judge always comments, Mr. Wisner, you don't have any notes when you're cross-examining. And I go, absolutely not. And that's something I learned at UCLA mock trial. And it blows the jury away. I mean, blows them away because they're like, this guy knows it all in his head. This guy knows everything.
It's like what they see on TV.
Exactly. Now, here's one trick, a technological trick. So when I'm doing my closing, I always use a PowerPoint, right?
Mm-hmm.
But what I do is I actually take a screen, I put it at the base of where the bar is between the jury and the lawyers, and I have the next slide that's going to be up. So I know what the next slide's going to be as I'm doing it. But they don't know that I know it's the next slide. So as I'm going through it, I'm like, and you know what? That is exactly what he said. Boom. And all of a sudden it comes up and they're like, how does this guy know? He knows everything. It's just like he sees into the future. And it's just because it's right there in front of my feet.
That's awesome. What do you think are the most pivotal parts of the trial itself? Because a lot of it is monotonous, a lot of it is perfunctory, and some of it is duplicative. What do you think are the parts of the trial itself where the trial is won or lost in front of the jury?
I mean, I think there's really a couple clear moments where to make or break in the case. The first is voir dire, jury selection. There's no question. I mean, you pick the wrong jury, you're going to lose. You pick the right jury, you can win. And you can lose a case in voir dire very easily. I remember my first case I ever tried actually out in Alexandria, Virginia. You actually came and saw it.
I came to your closing.
You came to my closing. And I did the opening statement. And Mike Miller, the same guy who actually tried the Pilliard case with me, and the same guy who, was injured for the Johnson case, he actually came to my opening statement in that trial. He went in, he saw the opening statement, comes back to the war room, and he goes, Brent, I just want you to know that was probably one of the best opening statements I've ever seen in my life. And you're going to lose. I said, what do you mean? He goes, look at your jury. And I looked at my jury, and there's nothing I could say to win that jury. I mean, it was never going to happen. I was never going to win that trial. So you can make or break the case of voir dire. The next moment is opening statement. Okay. Because that's the first time you're talking substantively about the case, and the jury is listening. And some people have different theories about it. Some people say, well, has to be short, punchy, get in and out. I don't agree with that at all. If you're going to make a jury give you billions of dollars, you have to show them that you earned it, and you got to show them everything. My opening statements run between 3.5 to 4 hours, which are very long. And then the next moment is your first witness, right? Because they're going to listen to what do you have to say? Let's hear what your witnesses have to say. So you always bring your rock star as your first witness. No question. And that one should be the most polished, the most clean. There should be no real evidentiary issues. That's the one where you just hammer them. And the last, and probably the most important part, very often people think it's closing argument, but it's actually not. Because by the time you get to closing argument, the jury's heard openings, they've heard all the testimony.
Right.
I think they know where they're going. They know what they think. It's their first witness. So the defendant's first witness. And there's no question that moment, you have to obliterate them. You have to destroy that witness as hard and as aggressively as you can, because if you can take out their first witness, they are done. And actually in Johnson, their first witness, I decimated. And in Pilliard, their first witness, I decimated. And it was clearly worked.
So in those two cases, who did Monsanto put up first? Was it the same person? And what were the strategies and tactics that you used to take down their first witness?
Well, it's kind of weird because every time I cross-examine one of Monsanto's witnesses, we never see them again. I think they just quit. They go, I'm not doing this anymore. This is not worth it. So in the Johnson case, their first witness was this guy named Al Khatib. He was a weed scientist, and it was hilarious.
Weed isn't like the things that grow in your yard.
Exactly. He wasn't like
it's San Francisco, so I had to ask.
No. I mean, that would have been funny, but no, he's actually how to kill weeds.
Okay.
People who smoke weed don't like this guy because he kills weed. In any event, he was up there, and it was really funny. He was wearing a suit with a purple tie and this whole getup. And when I was cross-examining him, I go, isn't it true that you've told the world that this international agency is actually very respected, and we have to consider what they say when they say something causes cancer? He's like, I've never said that. And I go, really? Well, here's a news article. I pulled this up out of Google where he literally was saying that. And he's like, I've never said that at any meeting. And I go, oh, really? And I handed him the article. He looks at it and he goes, looks at it, and I go, do you see that picture? Yeah. That's you, right? Oh, yeah. See that tie right there? Yeah. That's the same tie you're wearing right now, isn't it? Yeah.
No.
Yeah, it was.
All right. Experts buy more than one tie before you testify.
And he was just like, this is my favorite tie. I'm like, oh, it looks good on you, sir. But you did say that, didn't you? And he was like, oh, yeah. And then at one point I was like, you have a financial interest in whether or not people spray weeds. He's like, no, I don't. And I go, don't you have a patent? I do? Yeah. I handed him a U.S. patent under oath with his name. I mean, I decimated the guy. And then in the Johnson case, their first witness was Dr. Bello. And we had a moment between when she first starts testifying and before she offers an opinion. They do something, they lay your foundations. Are you an expert? Can you testify about things? And then there's a short period of voir dire. And it's funny because in mock trial, we always use that opportunity to attack the witness's credibility.
Right.
But during our trial, Monsanto didn't do that with a single one of our experts.
Huh.
The judge would go, would you like to voir dire? And they would say, no, Your Honor, we rest on our papers. Okay. And then we'd proceed. Here, the first witness, would you voir dire? And I go, yes, Your Honor, I would like to voir dire. And I walk up to the defense counsel and I go, you should sit down. This is going to take a while. And I just took her apart.
So the voir dire process when it comes to an expert is to test their credentials to make sure that they are capable of testifying. For some reason, we use the same French term that means to speak and to say for both jury selection and for experts. I don't know why. But so, yeah, I mean, that's pretty unusual because when it comes to these multi-million-dollar pieces of litigation, there is your Daubert motion, and you've already tested a lot of the gatekeeping functions of the judge, but you still have an opportunity to kind of put your chips on the table or try and take their chips away from their expert opinion.
That's right.
So that's not surprising to me that most lawyers and probably most defense lawyers are not going to be in the habit of really taking advantage of voir dire. But again, it's a great example of having an opportunity and taking it in a way that I think most lawyers are not going to do.
Yeah, and it also depends on the expert. I mean, if they're truly the most spectacularly qualified, it's not worth your time. Like, to give you some context, so let me give you a juxtaposition. So
Sure.
The first expert, I go through her resume and her CV, I talk about her publications, and basically at the end of it, and I kind of hammer her pretty hard at the end of it, she goes, yeah, I guess really determining what causes cancer isn't my expertise. That's what she testified. And at that moment, I stop. I look at the jury. Don't look at the judge. I go, Your Honor, I'm looking at the jury. At this time, I move to exclude this witness's testimony in its entirety. She just admitted she's not even an expert. And I'm not even looking at the judge. I'm looking at the jury. The jury's like smiling and laughing, kind of giggling, because they know I just took her apart. And the judge goes, denied, Mr. Wisner. You may proceed. And so I sit down. And so the first time she testifies about an actual opinion, she just admitted she isn't an expert. The jury just thinks she's a joke. So that was the first witness.
Yeah, I mean, the damage is done regardless of whether the judge has, excluded her testimony.
Exactly.
You've done the rhetorical damage, whether or not it is admitted to evidence or not.
Precisely. But then the next witness was actually my witness again. And he had a PhD from UCLA and whatever. And actually his opinions really weren't that important. But, I figured whatever. So the judge goes, Mr. Wisner, would you like to voir dire? I got to go, yes, Your Honor. And the jury's like, oh, what's he going to do this time? This is going to be really intense. Like, because the last one I was so brutal. I get up there and I go, Dr. Phelan, I have a very important question from you. And he's like, yeah. And I go, isn't UCLA the greatest university in the world? And he goes, yeah. And I go, good. I went there for college. No questions, Your Honor. I sat down and the jury's laughing. The judge is laughing. Everyone's laughing. I've underscored how bad the first witness was. And then at the same time, I've endeared myself to the court.
That's awesome. And also, it's good to get that in as a matter of law that UCLA is the best university out there.
Don't think it can be disputed.
Often these experts are going to be really world-class experts in their field. They're going to be talking about some kind of medical thing or mathematical thing or some science-based thing that we often don't have that kind of background. How do you go about preparing for cross-examining some other side's witness who has probably gone to school and specialized in some part of science that we have heard about for purposes of this trial, but we don't have that kind of background? How do you go toe-to-toe with someone who is an expert in their field?
During the Johnson case, they called this very well-respected toxicologist, Warren Foster, to the stand. And he was from Canada. And he had this long gray ponytail. And, he's walking up to the stand to get ready for his cross-examination. The jury hasn't come in yet. I walk up to the stand. I go, hey, doctor, can I ask you a quick question, a personal question? He was like, yeah, what's up? And I go, the ponytail. Are you a hippie or do you ride Harleys? And he looks at me and he goes, I don't ride motorcycles. He's a hippie. And it made me like the guy, And so my actual cross-examination of him was very pleasant.
Mm-hmm.
I was smiley, I was laughing, I was giggling, I wasn't mean. I was very, very sort of jovial. And I got him to say things that he never in a million years would have said. His big argument was that these tumors in these rodent studies fell within the historical range, okay, which is the percentage of mice that would get that tumor naturally, the background rate. And
so they've been dosed with Roundup, probably.
Glyphosate, but yeah.
Glyphosate. So one of the active ingredients in Roundup, these mice have been doused with this. Some of them, statistically, are going to get cancer or tumors.
Just by virtue of happenstance.
Right.
And so if you have elevated rates of tumors, it has to be above that background rate, or else you don't know if it's just the background rate. And his whole argument was that they fell within that background rate. So what that rate was the issue, right?
Okay.
He was saying it's 12%. My experts were saying it's 2%. And, which one is it? So he goes up there and I go, well, doctor, you would agree with me, sir. Numbers, they're important, right? And he goes, damn straight they are, especially when it's the number on my paycheck. And he didn't understand what he was doing. Like, he thought he was like being, an everyman person, relating to everybody, because everyone cares about the number on their paycheck. But it really looked like he was saying, make sure Monsanto pays me all the dollars they have to pay me to give me this testimony. And then I go through it, and it was amazing. It was a very Perry Mason moment, very dramatic. He's talking about the background rate, and he says it's 12%, it's 12%. I go, so you're saying the average is 12%? He goes, yes. And I go, all right, well, let's look at it. So I put up the study that he said, and I go through all the numbers, and it's 1%, it's 2%, it's 1%, it's 1%, 1%. And there's like 40 numbers, and they're all 1 or 2. There's one of them that has 12%. And I go, sir, when you said it was the average, I go, I'm not the best at math, but look at how in the world does that average to 12%? And he goes, picks up his glasses, he reads it closer. It's like a long pause, and he goes, yeah, I guess I'm just wrong. I go, doctor, it's a big man to admit it. No further questions. And I sat down, and that was the last question we asked the guy. And that was the last question they asked him. They couldn't even rehabilitate him. They were like, get him off the stand. That's how we kicked their butt.
Yeah, well, that's why you get tagged with a $2 billion verdict.
Yeah.
All right, so inevitably, when you get one of these multi-million-dollar or multi-billion-dollar verdicts, you get these people who say, this is just a greedy plaintiff or a greedy plaintiff's attorney who's just looking for a payday. The science isn't there. I've used Roundup my whole life. I've never contracted anything. What do you say to those people, especially since potentially they could be on your next jury?
I mean, I'd have to say that the strongest piece of evidence in our case is actually the science, which is, I kind of talked about this earlier. It's why we want scientists on our jury if we can get them, because they understand it. And when we look at the science of Roundup and glyphosate, there's really 3 pillars, okay? There are studies that look at actual humans who were exposed in the real world and says, okay, are the people who are spraying Roundup, do they get more cancer? That's the epidemiology. Then there's the sort of middle pillar, which is the sort of cellular studies. And that's like, okay, when we apply Roundup to a human cell, what happens to the cell? And specifically, we're looking for, does it cause genetic damage? Because that's how you cause a mutation that leads to cancer. And then the third pillar is the animal studies. They have these laboratory experiments where they study these animals for their entire lifetimes, and it's highly controlled. And they say, here are some that aren't exposed to any glyphosate. Here are some that are. And are the ones that are being exposed to glyphosate, do they get more tumors?
Right.
And when you put all the science together, it's pretty overwhelming. For example, in the animal studies, in every single mouse study that's been done, I think there's been 6 or 7 of them, every single one, there's elevated rates of malignant lymphoma. And we're talking about lymphoma. When you look at the cellular studies, it shows genetic damage in human lymphocytes, which is how you get lymphoma. And when you look at the human data, it shows that people who are generally exposed to Roundup have greater rates of lymphoma. Across the board, it's pointing in a specific direction. Now, one of the things that's really important, and you spend a lot of time educating the jury about this in voir dire and in your opening statement, is the burden of proof. Because if I had to prove something with absolute certainty that it causes cancer, it would be almost impossible. I mean, that is a high burden. But we just have to do more likely than not. The
preponderance of the evidence.
Exactly. We always have, you have a featherweight scale, right? And if you put one feather on one side and it just slightly moves, then we win. The way I like to tell the jury is, if you hear all the evidence and you go, well, I think it causes cancer, but I'm not sure. Good, we win. That's all we need to do. I think it might cause cancer. That's it. And when you have that lower standard, which is very different in the criminal context, but in the civil context, it's not that hard to prove. Now, if we had to prove it with absolute certainty, I think that would be a much different question. And I think very often people who go, you're just making up science, or you're not actually doing it, or this is just plaintiff's lawyers and inflaming the jury's emotions, they don't understand the legal system. And actually, the juries are properly applying and weighing the evidence in this case.
Yeah, I mean, that's a big difference between the civil system that is built to compensate victims for their damages versus the criminal system, where you have to prove, the state has to prove a crime beyond a reasonable doubt, which is a very, very high standard. And you can't ever numerically compare reasonable doubt to preponderance of the evidence, but if it's 51% versus 49% in terms of certainty, then the plaintiff should win if they've proved 51%. And unfortunately, I think a lot of people don't understand the difference between the burden of proof in criminal law versus civil law.
And that's why we spend so much time educating the jury about that exact issue from day one, from voir dire, when we're picking the jury. The other thing that's really complicated is there's actually a third burden, and that's for punitive damages, right? You have to show that they acted with deliberate disregard to human safety. You have to show that they acted with malice. And you have to show that not by preponderance of the evidence, but by clear and convincing evidence, which is somewhere in the sort of scale.
Yeah, somewhere between the two.
Exactly, between preponderance and beyond a reasonable doubt. So we don't know where, but it's somewhere in between it. And I think for that one, you simply say, does anyone here really believe that Monsanto wasn't trying to make money knowing that it causes cancer? And you know what? Yeah, then we're done, right? Getting to the malice proof is actually relatively easy. And in all three juries, that has been unanimous in every single case.
Wow, that's incredible. And it's also important to educate the jury, because the term malice in the punitive damage standard is not what we would normally think of in terms of malice. It's not like someone at Monsanto was like, I hate these people and I'm going to make them suffer. It's a term of art that has been defined by hundreds of pages of case law and jury instructions and statutory law. So you have to educate the jury, and sometimes you have to educate the judge at every step of the way, because we're tried by a jury of our peers who are people that are not lawyers, and they're not steeped in this every day like we are. So yeah, I mean, the education point is huge.
And I think it's something that when people get angry about these kind of verdicts, people say, oh, $2 billion, that's outrageous. This is what's wrong with the jury system. Those people don't understand just how important the jury system is to the way we practice law. Because, believe it or not, juries very often get it right. I mean, sometimes they make mistakes, for sure, but they're more often right than wrong. And it's a method that's fair, and it's transparent, and it gives us confidence that things are being adjudicated by our peers. And people who want to get away with disregard the jury system, they're either defense lawyers. Sorry, Mr. Stone.
I've spent a lot of time as a plaintiff's lawyer.
Okay. They either were defense lawyers, or they've never been in a situation where they felt they needed recourse to the jury system. Because if you're someone who's hurt, if you're someone who's been harmed, or really want to make a change because you see like something's wrong in the world, taking your access to the jury system away is a real problem.
Yeah.
And I think that very often with tort reformers or the hot coffee people and these people who think, oh, these juries are crazy, when you really dig down deep, you find out that, like, for example, the hot coffee story, it's not what you think. There's a great documentary about it.
Yeah.
And I think that it's really important for people to take a step back and not listen to that nonsense and actually say, okay, if I was hurt, what would I want? And if you were hurt, you'd want to have a jury too.
Yeah. So wait, so you're suggesting that a Twitter law degree is not the same as being a member of a jury and watching a trial from start to finish for 9 weeks and learning everything from start to finish. I find that hard to believe.
Shocking.
Yeah.
Who would ever thought?
It's crazy.
Yeah.
Just reading one article or maybe a tweet storm about it is not the same as actually being on that jury and listening to the facts on both sides for weeks at a time.
Yeah. I'll tell you what, you take all those people who are the trolls and the people who think they know better, you put them on one of my juries, the end of 7 weeks, they'll be singing the same tune, because unless they're dishonest with themselves, the evidence in this case is overwhelming, and there's a reason why the juries have been unanimous so consistently. I mean, these are people from different walks of life from all over the state of California who keep coming to the same conclusion when they see the evidence. It's because it causes cancer, and it's because Monsanto knew it causes cancer, and they just didn't care.
So in the Johnson case, you originally won $289 million on behalf of the plaintiff.
That's right.
That was later chopped down by the judge in briefing. But my understanding is that the jury, on their own time, wanted to dispute with the judge chopping their own verdict down. Can you talk about what happened there? First of all, is that true? Did the jury come back to support you?
It's unbelievable. And we had no role in trying to get the jury there, okay? So after the verdict, the judge has post-trial motions where she hears arguments as to why maybe the verdict should be thrown out or the verdict should be reduced or whatever. And she had written a tentative ruling, which is her initial thoughts of what she's thinking about doing. And in her tentative, she had actually gotten rid of the punitives and said we have to have a new trial. And she had basically said, I'm very seriously considering getting rid of the rest of the case, basically throwing out the whole verdict.
And that's crazy because judges rarely deviate from their tentative ruling. If they went to the trouble of actually writing down what they think they want to do, the odds of you being able to convince them to go against that. And here she was saying to get rid of all the punitive damages, which is most of the $289 million.
That's right.
I mean, the odds of being able to talk a judge down from that are, maybe 1 in 10.
Yeah, probably less. So we get there, and there's 10 of the jurors are there to hear the argument. They've read the tentative, and they're furious about what the judge is doing.
This is how long after trial?
This is, 6 weeks, almost 6 to 7 weeks after the trial.
So 10 of the 12 jurors came back a month and a half later after their service was already done.
That's right. They have no reason to be there. They could just go on living their merry lives. They've done their job. But they care so much about this case. They care so much about their verdict. They spent so much of their life doing this. They want to see what happens. And so they all show up. And we have this argument. And it's a rough argument. Monsanto is accusing me of all sorts of wrongdoing. And it goes back and forth. And that was on a Friday. That weekend, those jurors go on it's amazing. They go on Twitter, they start talking to news reporters, they go on the local television, they write letters to the judge telling her why she shouldn't do this, why it's wrong. And, the judge turned around her tentative. She kept the verdict, and she did reduce the punitive damages down. It was a $289 million verdict. She reduced the whole thing to about $80 million. So there was a big reduction. But she gave something called a remitter, which is sort of interesting. It's a complicated legal issue. But basically, the judge is reducing it, and if Monsanto pays it, the case is done. But if Monsanto appeals it, then we have the right to appeal the reduction. So if we accept the remitter, we cannot appeal it after they pay it. But so it was a sort of a trade-off, and Monsanto obviously wants to roll the dice. They want to play a $200 million game of chicken on the appeal. And we feel pretty confident that we're actually going to get the money back. So we'll see how it goes. But this jury cared so much about this case that I've never seen a jury do that. It's just unheard of. And actually, one of the jurors to this day has been going to the later trials and blogging about them and commenting on it. And he's now writing a book about it. And it's really cool how we got them so engaged as jurors that it's literally changed their lives, that jury service. It's pretty cool.
That's incredible. It's a testament to your skill as a trial attorney. I could sit here and swap war stories with you and listen to your trial stories probably for the rest of the day. Maybe we need to start a podcast or something. Let me ask you a couple quick rapid fire questions. The first is, what is your favorite lawyer movie?
I have to say my favorite legal movie would have to be A Few Good Men.
Okay.
That cross-examination when Tom Cruise is, I want answers. You think you're entitled? I want the truth. You can't handle truth. I love that so much. Completely inaccurate, but I love it so much.
I would be remiss, especially on Legaleagle, if I didn't ask you what you think the most inaccurate part of legal movies is.
It would be the time between when the case starts and when the trial happens. It's always like a month or 2 months or like a week. It's usually like 5 or 6 years. It's just preposterous how fast things. It's like in Game of Thrones, how fast they can travel between places in Westeros. It's just not possible.
Brent, it's been an absolute pleasure talking to you today. I could talk to you for hours, and I hope we'll get a chance to do a round 2. And I guess I'll interview you again next time you win several $1 billion from a multinational company.
Hey, Devin, it just occurred to me, that jacket looks amazing on you. Where did you get it?
Oh my gosh, thanks so much. I got it from Indochino, who's a sponsor of today's video.
Indochino.
By now, you guys know the drill. I love my Indochino suits, and I negotiated a special deal for Legal Eagles. All my suits are now custom made by Indochino, including the blazer that I'm wearing in this video. See, the secret to a great suit is all about fit. I'm a reasonably athletic guy, and I can never buy suits off the rack because they simply just never fit right. If the shoulders fit, the waist is too small. If the waist is right, I'll bust out of the sleeves. But with Indochino, you can send your measurements in online, or you can go to one of their stores and have a stylist take your measurements. I made an appointment, went to the store in person, and had a stylist work with me for over 90 minutes when I went in for the first time. All of that was completely free. My personal stylist took my measurements, and a couple weeks later, I got the best fitting suit of my entire life. It was perfect right out of the box. Indochino will make you a fully custom suit tailored specifically for you for less than $400. And the best part is they still use the best materials like Super 140 wool and cashmere. In fact, I asked Indochino to give Legal Eagles specifically the best possible deal, and they're giving you guys the exclusive ability to buy any premium suit for $359. That is the best deal you will find anywhere. I will never buy an off-the-rack suit again. Legal Eagles can get any premium Indochino suit for just $359 when you enter the code LegalEagle at checkout or use the link in the description. Clicking on the link really helps out this channel. That's Indochino.com, promo code LegalEagle for the best custom suit of your entire life.